since its inception, also in 1977, the Institute of Ismaili Studies has promoted scholarship and learning on Muslim cultures and societies, historical as well as contemporary. It has striven to encourage a better understanding of the relationships between Islam and other societies and faiths. As part of the Institute's remit to make modern scholarship accessible to a broader readership, Rafiq Abdullah and Dr. Muhammad Keshevji have spent the last few years working on the book. I think it's been a few years or a lifetime pretty much, but which endeavors to demystify Sharia and peel away some of the sensationalism which has surrounded the media in recent years. We might all benefit from this clear exposition of the history of Islamic law. How did it arise? How was it developed? How did it evolve? How is it relevant in non-Muslim majority countries? I believe that the work carried out by these two barristers, Rafiq and Muhammad, and written in clear English, will go some way to helping Muslims and non-Muslims alike to contextualize the whole issue of Islamic law and to gain a better understanding of how certain aspects can be dovetailed into modern life in both Muslims and Western societies.
Before we move on to a discussion of the contents of the book, I would like, first of all, to ask forgiveness from any native Arabic speakers in the room, but I would like to read a very short phrase written by the great 10th century intellectual Abu Hayyan al-Tawhidi, who was quoting a group of extremely eminent men. Sorry, it's men, right? We don't know if there were any women involved, but they called themselves the Brethren of Purity. And they wrote essentially an encyclopedia which covered everything that was known at the time. And Abu Hayyan quotes a lovely line with regard to Sharia, which, if you will excuse me, I will read to you and then translate. الشريعة قد دنست بجهالات واختلطت بدلالات ولا سبيل إلا غسلها وتطهيرها إلا بالفلسفة وذلك لأنها حاوية للحكمة الاعتقادية والمصلحة الاجتهادية. The Sharia has become polluted, and this is already in the 10th century, through ignorance and aberrations. The only way to cleanse the Sharia of this is through knowledge. That is because the Sharia is a storehouse of religious wisdom and social purpose. And this leads us on to the very book itself, and I would like to ask Rafiq to read two very short paragraphs from the introduction to the book, which will explain their methodology and approach and aim much more lucidly than anything I can say.
I don't know about that, but we'll have a go. This is what the bit from the introduction said. We consider that our approach enables us and our readers to think about or rethink the nature and reality of Sharia in the modern world, and especially in the Muslim world. Now, this process entails raising issues that offer a critique, but are not intended to be polemical or partisan in ways that provoke or obscure. The importance of understanding the complex nature of Sharia cannot be overstated in a world of over 1.6 billion Muslims, some of whom live as minorities in non-Muslim countries, in various cultural, linguistic, and economic and ethnic communities, and who are struggling to reach new levels of material, intellectual, and spiritual development without abandoning the values and ethics of their faith. These issues cannot be understood as an abstraction, and they should be situated in an historical framework of understanding that takes into account the origins of Islam and Sharia and their development from the classical period to modernity within the context of other civilizations and other legal systems. Now, this study aims to provide different perspectives rather than prescriptive answers to particular issues in the contemporary world, such as finance, social governance, environmental problems, criminal justice, alternative forms of dispute resolution, human rights, biomedical ethics, and the role of religious law in the establishment of modern states. All these raising important ethical questions about and practical problems around the development of Sharia. That's a start. We kick off with that.
Thank you very much, Rafiq. And the first question that I would like to ask you, perhaps either of you would choose to answer, is what motivated you two British-trained lawyers living in a country where Sharia law is an intellectual rather than a practical issue to decide to write a book on Sharia? What was the need that you found?
We've been asking ourselves that question all the time.
You've been asking it.
Actually, Russell, I don't think it's only an intellectual issue. The Sharia is becoming a real issue in this country because by the very process of conflict of laws, you have 3 million people living in this country. So at some point in the jurisprudence of this country, Sharia does come up in one way or another. In today's conflicted world, Sharia becomes a metaphor for the growing chasm between the world of Islam and the rest of the world, perceived or projected. And we thought that there is a need for a book for the educated lay reader that explains not what Sharia is, but what it is not. Because many things get mixed up with the word Sharia, which may not be Sharia. Now, Rafiq, you may want to add to that.
Well, I suppose the one word that comes to mind is curiosity. Because, I mean, even though as I think someone mentioned that my mother's grandparents were imams, etc., the household that we lived in, yeah, we were Muslims, but it was not a big deal. And Sharia certainly was not discussed in any way at all. We talked about music, culture, and all that sort of stuff, but we'll talk about that later again. So it's curiosity. Mm-hmm. And Muhammad bullying me, but that's another story that you know from next door.
Does he listen to
anybody?
He's
very persuasive. So I don't regret doing it, actually, because being brought up as, if you like, an Anglo-Saxon lawyer, I knew nothing about Sharia. And when we started to study it and research it, I discovered a lot of things that I didn't know before. And we will talk about that later as we go on this evening.
What has interested me is why when we look at the various faith communities in the United Kingdom, for example, the Orthodox Jewish community has been able to set up Beth Din courts that have been absolutely normative and have not aroused any latent hostility or sensationalism around them. And we haven't yet defined, which we're going to do a little bit later, what actually Sharia is. We're still talking about a very abstract concept. But why do you think, for example, that I can't ask you about the Christian community, the Anglican community in Britain, because that's completely clear, the answer. But why, for example, has the Orthodox Jewish community not encountered any hostility in setting up their own religious law courts to deal with personal status matters, etc., whereas anything almost that any Muslim community does that has this tag Sharia attached to it is tendentious?
You know, I've often wondered about this, but one thing comes to mind, Russell, is that Britain or the colonial powers have had a long history of connectivity with the world which was peopled by Muslim peoples. So Holland with Indonesia, France with North Africa, Britain with India, 300 years of engagement. But I think that the Jewish community had a closer contact within a diasporic setting with a colonial power, which probably goes back 300, 400, 500 years. I mean, Oliver Cromwell called the Jews back to England after they were expelled in the 13th century. So my particular take on this is that the connection of living as a minority in a larger polity perhaps was there earlier with the Jewish community. The Muslim community in this country is still very young. You know, we hear a lot about the Sharia councils, but it's a 40-year-old phenomenon. Mm-hmm. As far as I'm concerned, I did my doctorate. I mean, my professor is here. I took one Sharia council. I remember when I started my whole project, I think Michael Palmer told me, is it 1 PhD or is it 5 or 6? So there's a lot of more study that has to be done of a community that's relatively new. Yes, Britain has a connection with Islam that goes back to 300 years. But as a phenomenon of a minority community that has come here to stay is a relatively recent phenomenon.
Thank you very much. Mohammed, in your book, you insisted that perhaps the easiest way to describe what Sharia is was through a diagram. And I'm going to ask you if you can tell us a little bit, using your beautifully designed diagram, the differences between Sharia, fiqh, and customary law. And why are these differences so important? So perhaps you would explain to
Yeah,
the
if you don't
audience.
mind, Russell, my walking around, as long as I don't fall off the stage, maybe I can come closer and show what this particular graph is meant to signify. And it took us a little time to work this out. The relationship between a Muslim and God is a vertical relationship that is exemplified by prayer, by the giving of zakat or the alms to the poor, by pilgrimage, by fasting, and by the affirmation of the shahada that there is no God but God, and Muhammad is his prophet. And that is known in Islam as ibadat. Ibadat means worship. It's a vertical connectivity. But a Muslim also has a lateral connectivity with his or her fellow human beings, which is known as mu'amalat. It's transactional. That's where law resides as we know it in the West. Marriage, divorce, custody, maintenance, questions of contract, questions of criminal justice, if you may. So there is a lateral line called mu'amalat. And then there is a relationship between God and the individual believer with the environment, which is exemplified by the notion of trust, amanat. We don't own the patronage of the world for ourselves to deplete, but we have to look after it. It's a stewardship for future generations. So that is your third point. Now, we would argue that the line between God and the environment is your Sharia. It's a straight line, but it's not a rigidly fixed line. On that line, Muslims, communities of interpretation, for the last 1500 years, had to make a discovery of what the divine legislator, which is God, meant for Muslim communities to lead a better life. So Sharia, while Sharia is divine, the understanding of that line is human. It's human beings, communities of interpretation, with their different systems of understanding that created what you call the fiqh, or jurisprudential understanding. That means every Muslim community has their own school of law. There are 4 Sunni schools, the Hanbali, the Hanafi, the Maliki, the Shafi. There are 3 Shia schools, the Fiqh Jafariya, the Ismaili, the Zaidi, and then there's the Ibadi school of law. Now all these schools are located on that spectrum, on that line. And so the importance is that in the 1500 years, it's a work in progress as each community of interpretation encounters new situations in life, to which the Quran says, use your mind, exert your mind, ijtihad, try and understand the world. Understand God's creation through the use of your mind and your intellect. Now, why, may you say, is this important in today's world? To crown your question. People conflate Sharia, which is divine, with the understanding of it at time-specific locations, which is the fiqh. And the fiqh, or the jurisprudential understanding of the Sharia, is not only the principles of going to the Quran or going to the Sunnah, which I'll explain a little later, or using your analogical reasoning, but Islam embraced customary law. Historically, Islam embraced customary law. It did not reject. And that is still happening today in places like Yemen and northern Nigeria and Indonesia and places. And also, Islamic communities absorbed and embraced other systems of laws. So things that Muslims today call specifically Islamic, like waqf, to hold trust property, is not from Islamic law. It's from Byzantine and Persian and Roman laws. So basically, when you see the whole picture of Sharia, we've tried to put it into what you call in America an elevator speech. But this is how we see it emerging. And of course, people will have different ways of graphically putting it forward.
Well, this actually leads us on to our next question,
Right.
which I'm going to address to you, Rafiq.
Yeah.
Because at the heart of the book, you write about the need for interpretation of Islamic law, which we could say is fiqh here, and about the complexity of the Islamic legal system as we see it, or in fact as it has been complex for many hundreds of years. Can you tell us what you mean by interpreting the law?
Yeah.
And why is this more of a problem than it would be in a secular Western situation?
Right. Now, I have a poor memory, so I'm going to actually use some of the stuff I've written to explain a bit more about this. Interpretation. We interpret all the time. We interpret facial expressions, we interpret body posture, we interpret the clothes we wear, the tone of our voices, the things we see, touch and feel. We interpret. It's what we might call semiotics. We're bound to communicate. We're bound to receive and decode communications. Well, that's what we are here for as human beings. That's what we think. And one object which mainly consists of interpretation, except in the most basic terms of information or direction, is a text, reading or listening, a written object which is either read or heard. And the heart of language, which a text is made up of, is interpretation. We receive it, and we are compelled to make meaning out of it. If you like, the poetics of language, hermeneutics also. So we learn the lingo, so to speak, from the time we're born to make sense of the world around us. Now, in the book, as you remember, Muhammad, we argue, and I hope we show, that Sharia or Islamic law is essentially created by interpretation. Yes, we have an orthodox thinking, Islamic thinking. The Quran is the word of God, and we have 10% of it is Sharia, but the rest of it is created by man, constructed through various methodologies, which you'll talk about a little later on. But at the end of the day, the central text of the faith even is not just the Sharia, but the central text, it has to be interpreted for many reasons. For example, it is an ancient pre-modern text. So how many Arabs today will understand it? It's a text which is poetic in expression. In fact, we enjoy listening to it, the beauty of it, the musicality of it. It's a text that has syntactical gaps which are set in pre-modern contexts. So we have to be aware of context. And these contexts are excavated by scholarship that inevitably is open to debate, disagreement, and most importantly, to my mind, it is a text setting out a faith which claims to be universal, but which is in a human language called Arabic, which is not spoken by most Muslims in the world. Thus we, and I include you and me, Muhammad, thus we, not you, I'm afraid, sorry, you're out of the state, but Muhammad and I, we do not have the problem not just only of interpreting an Arabic text. We have to have it translated by the likes of Russell and others before we can understand it. And we all know translation is an approximate practice. So we're always going to have elements of argument and discussion. Now, the same points obviously apply to legal texts, which reflect development and the implementation of Sharia, and that's its fiqh. And they are mostly in Arabic. And they have to be read and developed. They've been developed in the past, and they are inevitably have to be read and reread with new eyes and new expectations. So we discussed these points in the last chapter of our book, where we invite Muslims and non-Muslims to exercise what I call the practice of critique, which not only explains the law, but analyzes it and enlivens it by making it relevant to our modern world. Now, clearly, Western secular law, as indeed in all law really, it requires interpretation. And I would argue that this law, which is rule-based, which has a body of accumulated common, if still approximate, understanding, which becomes collected into a corpus of decision-making or precedent, as our lawyers here will understand what I'm talking about, and non-lawyers, which are recognized and created by constitutionally recognized courts, is more compelling in this regard of interpretation. I'll be very quick here. There's a paradox here, an important paradox. Sharia claims to be a law sanctioned by God, by sovereignty residing only in the divine. But the explanation of that sovereign sanctioned law does not have a finally authoritative explicator, at least regard to Sharia as practiced by Sunnis. The Shias are a bit more fortunate, if you like, because they have the authority of the imams, but that also needs interpreting. But the area of disagreement amongst the faithful is more, if you like, curtailed. Now, there is a disturbing paradox here. As I said, most Muslims do not have Arabic as their native language. So they're at a disadvantage from the beginning with regard to understanding the Word of God. This disadvantage is added to by the way the Quran is taught, which is learning by rote. Muslim children learn to read the signs on the page by memorizing and mimicking the beautiful sounds, but do not understand their meanings. Never mind the various layers and arguable complexities of meanings that are embedded in the Quranic verses, which invite sensitive readers to read with due modesty. Now, this type of teaching may create a discerning ear. It may deliver a degree of pious satisfaction for the purpose who learns to read in this way. But it does have an immense deficit in learning to understand the text, its ambiguities, its implicit and apparent contradictions, and so on, which calls out for interpretation, which is not only a form of scholarship, but actually it's a mode of being requiring a questing and questioning attitude from the reader. Sadly, we argue that this essential condition of interpretation is lacking in the Muslim world today. And thus we encounter, I'm sad to say, dogmatic, politicized, simplistic interpretations, pretending to be the authoritative truth, the application not only of the law, but of the faith itself. Make no mistake. To my mind, crude interpretations of the law and the sacred texts, whether in Islam or indeed in other faiths, both religious and secular, lead to a coarsened understanding and the brutal opinions and acts as we see across the world today. So it's not just religion, it's ideology as such.
Thank you. That was a very fulsome answer. I'd just like to make one other little observation that in my experience and my reading, I've noticed that, for example, in other religions, which I'm speaking about with great respect, for example, in Catholicism, the Bible was in Latin and the community was not expected to understand the holy text and to draw their own legal rulings from it. That was generally left to the great experts. Now, I've got one other question for Mohammed, and then we will turn to Rafiq. The 19th century, as you pointed out, from the Ottoman Empire and the institution of the Tanzimat reforms, seems to be a turning point in the evolution of Sharia, perhaps the first time that an Islamic state or a state based on Islam felt that it needed somehow to dovetail its legal code with the needs of modern times. And perhaps it also had something to do with the interests of the major empires of the time, the British and the Russian, who were the, of course, competitors of the Ottomans. You speak in your book of the Tanzimat reforms of the 19th century, as well as bring us up, right up to the Arab Spring in the 21st century. Has the Arab Spring in the 21st century got some basis in Islamic law, or is it somehow driven by a concept of what people believe the Sharia demands of them?
I've been looking at the Arab Spring discourses, and it's very interesting, the two images that come into my mind. I mean, what started the Arab Spring was that Bouazizi, was it in Tunisia?
Yes.
And unfortunately, self-immolated. What was his quest? His quest was really for social justice, governance, accountability. It's very interesting that if you look at them our book mentions Tawakkul Karman. Tawakkul Karman is a Yemeni woman, the second woman to win the Nobel Prize for Peace after Malala. And Tawakkul Karman was able to mobilize thousands of women in Yemen and got to New York and stood outside the Security Council and said, look, you cannot give any particular amnesty to Abdullah Ali Saleh. Is it Abdullah Saleh?
Yes, Saleh, the Yemeni
Saleh,
president.
because he's accountable for his deeds. Tawakkul did not mention the word Sharia once. Mm-hmm. She was speaking about accountability. She was speaking about governance. And what seems to be emerging from the discourses, of course, it's not uniform between Libya, Egypt, Tunisia, Yemen, Syria. The question is that while there is a recognition that Islamic ethical principles as embodied in the Sharia give you enough of a voice to speak about injustice, does that voice allow you to run a modern state on Sharia principles as they are understood? Right. And I think that we're seeing a maturing process in that development of that understanding. Still very new, few years only.
And of course, across the Arab Spring, we often hear of people calling for a return to Sharia, but I think we should really interpret this as people saying what we would like is law and order to exist in our countries in a fashion which is compliant with the precepts of the Quran and fiqh as it has developed from it. Now, I'm sorry.
Most of these people speak from a point of ignorance. They don't know what fiqh really is.
Am I included in that?
No, you're a scholar, but I'm talking about the people going, asking for a return to Sharia, return to fiqh. You've given a wonderful historical account, if you like. One of the things that we don't know the answer to it, but that first 90 years, and the question that hits me is that how did it happen? And we get this thing about Islam being a religion of peace, etc. In fact, power and conquest was very much part of the Umayyads' story. And you haven't mentioned, and we will discuss it perhaps a little bit more, we do discuss in the book how fiqh actually developed. There's a whole science about fiqh, which I would argue is one of construction. It's constructed. Right. Constructed relating to the time and the context. Sure. And the Sharia was always having to grapple with and engage with customary law. And continue, as you said, continues to do so. One of the things you didn't mention was, we mentioned earlier on about the notion of obedience. Obey the Prophet and obey those who came after him and those. That is, for me, a very problematic notion, obedience, right? Because at the same time, the Quran says, seek knowledge even unto China. Seeking knowledge means actually not being too obedient, asking questions.
Yes, questions.
And one of the problems we have in Sharia, even today, is when imams say the Sharia says so-and-so and so-and-so, and everyone's going to nod, yes, that's what the Sharia says. They don't actually get into the practice of asking where, why, and how.
Now, signals are being given to me that we are a little bit behind, so I'm going to jump a question and turn to Mohammed, who is a great expert on alternative dispute resolution. And in the field of alternative dispute resolution, Mohammed, there are various concerns with regard to Sharia councils in this country. But very important developments have taken place globally that you mentioned a little bit earlier, with regard to international interspousal child abduction. Perhaps this is something that we are all aware about because we will read it in the newspapers when someone takes a child from a broken marriage and flees, let's say flees to a Muslim majority country in the knowledge that it will be very rare for a judge to grant custody to a non-Muslim spouse in a Western country. Can you tell us a little bit about developments in solving this problem over the last 10 years? And again, I'm being asked if we could make it a little brief.
I'll try and be very quick. Basically, in a globalized world, we're progressively seeing our children marrying out. So we have marriages that are biracial, bilingual, bicultural, bireligious. Name all the bis you can think of. And I have a theory that when people are in love, nothing's a problem. It's when the difficulties start and what didn't seem to be a problem eventually becomes a problem. But there's a real problem here, that if a mixed marriage takes place, a binational, biracial marriage takes place, if there's a problem and one spouse takes the kid outside the jurisdiction and leaves the country, our present global system does not allow the law of the residence where the child was snatched from to reach out to the other country. It's a global problem. So in 1980, the Hague Conference of International Law, private international law, promulgated what is known as the Hague Convention of 1980, which gives the country from which the child is snatched the authority to get the child back from the other country. And the other country is party to the treaty, will send the child back. Now what happened is still today, less than 50% of the world's countries have signed up. So we still have a problem. And the difficulty was about 91% of the countries from the Muslim world refused to sign up. It said it's got nothing to do, it's contrary to the Sharia. So over the last 20 years, what's happened, the Hague Conference of Private International Law set up a committee with a Canadian ex-diplomat and a Pakistani incumbent judge. And they set up a committee with 22 people, 11 from the Muslim world, 11 from the Western world. And they wanted to know what was the Sharia take on it. I was quite fortunate that I was part of the process of writing a chapter in the book, but I can't take credit to say that the Muslim countries joined because of the chapter that I was responsible for writing. But eventually, after talking to jurists, Muslim imams, we came to realize that the concept doesn't exist in Sharia. In Sharia, you cannot charge a father for taking the child away, because the father can say, I've got to take the child away. I want the child to be brought up as a Muslim. That's my God-given obligation. So the notion of international child abduction doesn't exist in the Sharia. But what we were able to excavate from the Sharia was a principle known as ugwa. Ugwa means kidnapping. And we found out that in Sharia, a child is entitled to access to both the parents. And so when one parent abducts a child, it's a crime against the child. So the Sharia gave us one opening. Second is the Quranic ayat that says when you have a problem between a husband and wife, get the two together and mediate. The third point is a hadith of the Prophet, paradise lies at the feet of the mother.
Right.
And fourthly, this great principle of darura and maslaha, public interest, necessity. So we put the whole thing together and we said, Sharia doesn't reject what the Hague Convention is saying. The Hague Convention reinforces the Sharia principle. And I'm very happy to say to you today that I just had a communication with Christophe Bernasconi, the Secretary General of the Hague Conference. I sent him an email last night that since that time, Morocco, Pakistan, Tunisia, Iraq, and hopefully very soon Indonesia are all becoming parties.
Wonderful.
So as of the next few months, 500 million Muslims will be in the system participating in this dialogue. And it was done not through confrontation, it was done through mediation.
Fantastic, and that is your particular area of expertise. Now, We could sit here, we three, and talk about this for hours, but
Which
we're
we've
going to
done,
have
which we've done
we're
many
going to
times.
have pity. And I would just before we throw open the floor to a few questions, I would just like to mention a couple of subjects that are covered in the book which we have not got time to talk about this evening. But if you do acquire the book and read it, you will find that many contentious subjects have been dealt with, subjects such as female genital mutilation, forced marriage, honor crimes, and many of the other issues which we read about in, I can only talk about the UK press, in a sensationalist and sometimes aggressive manner. These two eminent authors have covered it in a very calm, rational, clear, and communicative way in the book. So, if you excuse me, I'm going to bring our chat to the end, and we will have, I think, a little time for some questions from the floor. So if anyone has some questions. Zehra, I believe there is someone over there by you.
Please keep the mic very close.
Okay. Hi, good evening. So I have a question addressed to Dr. Keshavji. And so my question is, well, firstly, thank you very much for the discourse tonight. It was very interesting and very illuminating. But I noticed you didn't mention anything about the understanding of Sharia and the recent role of women, and also the discourse that goes with that, and the narrative, the counter-narrative. It could be that it's mentioned in the book. As I said, we haven't seen the book yet, so I'm hoping there will be a chapter or two on the subject in the book.
Thank you.
So the question I ask of Dr. Keshavji is, can you mention a few words or say a few things about the role of women in understanding the Sharia?
Can I bully you and ask you to do it?
Yeah, I'll do it because...
You got to.
Yeah, I'm sorry, I'm sure you'll add to it, but, you know, where do I start? Really, where do I start? Yes, our book deals with women and the issues concerning them, but I can only touch on this very important topic now because we haven't got enough time. I've been told to move on. When we started looking at this thing, and we're talking about issues of inheritance, polygamy, divorce, and other issues which place women in subordinate positions. Now, let me tell you a quick story about when I was researching this. I read a scholar arguing about why is it a woman's evidence in court is worth half that of a man. I mean, that alone just irritated me, and I'm a man, a Muslim man, Sunni Muslim man. What on earth is that all about? Why did this happen? And I read somewhere about, a modernist Muslim scholar saying, well, you know, there is a reason for this. Please bear with me. And he said, and I quote, women's testimony is disregarded because females are preoccupied with domestic skills which prevent them from developing memory skills. Memory skills.
Wait.
Precision in details and proficiency in such public matters as contracts. Now, I wondered what his wife must have said to him for starters. I know my mother, who was a doctor, and her female cousin, who was a feisty anti-apartheid political activist in South Africa, would have said to him, because basically, get real, you know, what are you talking about? But never mind them. I wonder what Khadija, the Prophet's first wife, who was his employer, by the way, so she was running a business, and she employed this man who wasn't a prophet at the time. What she would have said, and she, by the way, protected him when he had the first revelation because he thought he was going mad, and he calmed him down, this person who could only have half the value of a witness. And what would his youngest and most beloved wife, when he later married, say about it? This woman went to war. She argued with the Prophet. By the way, the Prophet may have been a prophet, but as a man, people would argue with him. And she certainly argued with him, who also had, and I want some studies to be done about this, she collected her own hadiths or sayings, which we need to know more about. Now, that's just those two people. But in the Muslim world today, as Muhammad knows, we went to a memorial service of a great Pakistani activist called Asma Jahangir, who died about two or 3 months ago. And she didn't mince her words about Islamic matters and women, the way women were treated. Then there's the Sisters of Islam in Malaysia. And the Nobel laureates, Malala, as we know, Yusuf Zai, and more recently, you've just mentioned Tawakkul Kawan. There are many, many other women who are challenging the patriarchal nature of Islam. They need to do it, and they are doing it as understood by male Muslim jurists. And they live dangerously, yes. I'm very carried away about this. And with amazing courage. Long may they live, and long may they fight.
Yeah. What a... Just to add that these subjects are covered in the book. Do we have another question? Mahmoud, please.
Yes.
He's a lawyer. I've got to watch him.
No. It's good. It's an easy question for you, actually. It's about the ethic of good governance. Now, we know we live now in times where governance is a big issue, whether it's in civil society or in the corporate world. At local government, central government, governance is a central issue of our time. So the question for you both is, can an Islamic frame of reference on the question of governance tell us anything at all that we should take notice of with this issue? And just to add a bit of color to it, we know about Tunisia and the fact that it has had a new constitution. And there was obviously a lot of work that went into that constitution. And so the question really in a more specific sort of way is, amongst Muslim countries, is there a need for a constitutional rethink along Tunisian lines? And more generally, the earlier part of my question about governance as a whole from an Islamic frame of reference. Thank you.
You're very good at that.
I think constitution rethink is so critical, not only in the Muslim world. I think in the developing world, certainly even in the developed world. I think the Tunisian experience is very salutary, but it wasn't easy. This took 2 to 3 years. There was mistrust. There was a lot of arguments, there were disagreements. There were assassinations too. But I think what is important is that the judiciary in Tunisia stepped back and allowed the parties to arrive at their own negotiated settlement. And to the credit of a person like Ghannouchi, I think they realized that while they could bring people on the public square to speak about an existing order, to constitute a government purely on Sharia law would not be workable. There were existing rights, there were newly found rights, and how do you allow all parties to work together in a compact? But I think the Tunisian experience is something worthy of looking at. My mind also goes back that L.B. Sachs spoke about this at the Global Centre of Pluralism. I think of the South African judge of the Constitutional Court. And there's another example of constitutional thinking. I think what is needed, not constitutional rehauling, but a constitutional rethink which is creative and takes into its embrace the other, the diversity of the demographics, the new situations in which Muslims are finding themselves, and finding a compact that would be workable. The short answer is yes. I think it's an area that really needs a lot of work.
Thank you, Mohammed. And I would like to take one final question because of time, but I insist upon it coming from a lady member of the audience.
Sorry. Sorry.
We have Dr. Asma Hilali here, if you don't mind, who is a lady.
Sorry, man, we have to stand true to what we said in the book.
Yes, ma'am.
Yeah, my question is, do you think that Sharia is compatible with modernity? Can we be modern and be Muslim today?
The question begs a lot of questions in itself. What is it to be modern? And what is it to be, in a world that is already in turmoil and for many reasons? One of the things about we make a distinction in the book, as you know, Mohammed, between ethics and Sharia. We talk about ethics and Sharia. And Sharia is concerned with morality, and ethics is an open-ended philosophical question. That's the first thing that we've got to understand, that Sharia is very keen on obligations, and that which take precedence over rights. So there's an element here where we in the modern world talk about human rights and autonomy, individual autonomy. Sharia is saying, okay, you also have duty to the, if you like, the environment, to your community. So there is a starting point there. And Muhammad, you know, we talk about the three things about Sharia, darura, maslaha, and maqasid. If you could say a little bit about that, would help, really.
You know, I think that there are principles that are built within the Sharia. There's a principle called maqasid al-Sharia, which talks about the higher value of Sharia, which protects life, intellect, property, offspring, and religion. Now, that's a troublesome area, because who decides that? But certainly, if Muslims are going to be stuck in the metonymic, rule-based, tradition-bound, usul al-fiqh approach to Sharia, perhaps not. But if you look at the purpose of law and the notion of the public interest, the welfare, and the necessity point of view, I think that with new thinking, the essential values of the Sharia can speak to the, not to Muslim issues, but to global issues. But it cannot be in its pre-modern frame of mind. So I think we cannot say that the Sharia has to be thrown out the window and we'll get modernity coming in, because modernity is a troublesome concept as well. But I would say that new thinking, ijtihad, creative thinking, like we've seen in certain areas, could help Muslims to excavate from the Islamic legal tradition values that can be spoken in a renewed voice for the world in which we're living. With all faith communities. I would say this about Judaism, I would say this about Christianity, I would say that about Buddhism. We cannot have, we need to have freedom of religion, not freedom from religion. We need to understand those concepts. It's a long debate. But I am a great believer that with the modern disciplines of thinking, of knowledge, and very genuine understanding of the role, the social purpose of law in society, Muslim thinkers, in conjunction with other thinkers, can bring to bear new thinking on the table for the modern world.
So in short, Asma, yes, but hopefully.
Thank you very much.